Thanks for having me. So like Ilyas mentioned, I'm Abhilasha Ravichander. Today I'm going to be talking about how NLP can benefit consumer privacy. And this is joint work with my collaborators, Alan Black, Thomas Norton, Shomir Wilson, and my advisor, Norman Sadeh, who is a lead PI at the Usable Privacy Policy Project. So I want to start by thinking just broadly about what is privacy and why is it important. So Weston, who many consider the father of modern digital data privacy laws, said that privacy is a right for people to control for themselves when, how, and to what extent information about them is communicated to others. So this means that privacy is central to our ability to operate as autonomous individuals. And it allows us to reflect meaningfully on things like political processes and social norms, for example. So in this way, privacy is central to our ability to support democratic ideals. But nowadays, in the digital age, privacy is threatened by entities who aggressively and automatically collect digital personal information. And digital privacy is fundamentally linked to the ethical principles of transparency, fairness, and agency. So according to transparencies, users have a right to know how information about them is going to be collected and used by any entity. So this also means that entities should not be engaging in any kind of manipulative practices that are designed to increase the willingness of some consumer to give up their data. So according to fairness, users should be receiving value that they think is proportionate to the loss of privacy associated with the disclosure and use of their data. And according to agencies, users should have a choice about what data is collected about them and how it is used. Sorry. And digital privacy is nowadays largely operationalized through privacy policies, which are legal documents that disclose how companies gather, use, and manage user data. But these policies are long, they're verbose, they're complex, and they're difficult for most users to read and understand. Why are things this way? Privacy policies operationalize notice in the notice and choice regulatory framework. So what this means is that in theory, privacy policies will describe an entity's data practices, and users are supposed to read the policy and then only decide to use a service if they find the conditions outlined in the policy acceptable, subject to a few opt-ins and opt-outs. But in practice, users seldom read privacy policies. And it's not really on the users, this fact that privacy policies are not read. This study by McDonald and Crenov found that if users were to actually read the policies of all the services which they interact with in a year, they would spend up to 300 hours per year just reading privacy policies. So the current scenario is that a majority of people do care about their privacy, but according to this Pew study, 91% of people in the US have reported feeling like they've completely lost control over their information. So in this talk, I will be describing the potential for language technologies to make information in privacy policies more accessible to consumers, to regulators, and to developers. And so this is going to be the rough outline of this talk. I'm going to first describe what research has already been done in applying NLP to process privacy policies. And then I'm then going to describe challenges that keep us from building effective NLP tools in this space. And finally, I'm going to describe new areas where or new NLP applications which don't exist yet, but perhaps they should. And so I'm going to start by describing 5 NLP applications, and a lot of the work that I'm going to be describing some of the early success stories of the Useful Privacy Policy Project. So the first application I want to talk about is data practice identification. And this was one of the early NLP tasks in the usable privacy space. So the task is basically whether we can identify privacy related topics in privacy policies. And one of the early efforts to do this was this paper led by Shomir Wilson, Wilson et al., the creation and analysis of a website privacy policy corpus, where the corpus is called the Online Privacy Policy Corpus. It consists of 115 privacy policies annotated with data practices. So the idea is that once these policies have been tagged with data practices, users can more effectively navigate them. This paper trained machine learning classifiers to identify these data practices, and then these classifiers were applied to 7,000 privacy policies. So let's look at an example of what this looks like. Oops, sorry. Sorry, I should have done a control tab there. Okay. Can you see my screen? Okay, great.
Yeah, sure, we can.
Awesome. So on the left, you can see the data practices. So these are things like first-party collection and use, or what a service provider, or why and how a service provider will collect user data. Third-party sharing and collection, why and how, to who is your data shared and why is it being shared. So tagging the data practices allows the construction of this storyboard that you can see on the right, which describes the distribution of different topics in the privacy policy. So now if a user wants to know more about, say, which third parties is their data shared with, they could expect to navigate to the sections describing third-party data sharing. So this is great, and it was one of the early success stories. Another application that was successful was choice identification. And so the task here is basically to identify choices that are available to users, because most consumers do want control over their information, but many services do provide some kinds of choices over what data will be collected and shared, but these choices are typically buried in long privacy policy text. And what this leads to is that even though there are a few choices available, most people are unaware of the opt-out choices available to them. So two representative works in this space aim to use NLP techniques to extract choice language. So this is work led by Kantashi Satyendra and Vinay Kumar. And the latter paper, so the success story here is that these techniques have actually become very accurate. So this paper led by Vinay Kumar reports that they are able to identify 90% of the choices available to users. And they actually have a browser extension that's available for Chrome and Firefox users. It's called Opt-out Easy, and it can be downloaded. Okay, so far we have reviewed applications that automatically tag segments in privacy policies and applications to extract choice language from privacy policies. But what about making information in the whole information in the privacy policies more accessible? So one research direction that is appealing is to do policy summarization, where you try to generate short summaries of privacy policies. But there are actually many challenges in this space. So if a summary is too long, users may not read it because it might be as prohibitive to them as just reading the privacy policy. But if the summary is too short, users may miss out on salient information that is actually present in privacy policies. And there's more discussion on this topic in this paper by Gluck et al. Called How Short is Too Short. But beyond length, the challenge is that different users have different concerns, expectations, and background knowledge. So it's very difficult to construct kind of generic summaries of privacy policies that are going to meet all these user needs and requirements. So Another promising direction is the development of privacy question answering, because now this can be personalized to each user, because each user can selectively explore the issues in privacy policies that matter most to them. But there are many challenges in this space as well to develop effective question answering functionality, because you need to understand the types of questions users are likely to ask, how users are going to formulate the questions, and what kinds of answers are actually going to be helpful to users. So I want to briefly describe some early work in this area, and this is still a really nascent field, so it would be great if there was more research. I'm going to describe the Privacy Qa corpus, which consists of 1,750 user questions with answers provided by legal experts. And I want to talk a little bit about how this corpus is constructed, because traditional QA corpus collection methodology typically involves showing users or typically crowd workers passages and having crowd workers ask questions about them. But we don't really want to do this with privacy policies, both because we can't really expect crowd workers to process privacy policy language meaningfully and ask good questions, but also we don't want to limit crowd workers to asking questions only about things that are there in the privacy policy. So we tried to have a more ecologically valid data collection procedure that would scale. So what we did is that instead, we showed crowd workers descriptions of the app as they are available on the Google Play Store. And we asked them to imagine what kinds of questions they would ask if they were thinking of installing this app. So without reading the privacy policy, crowd workers generated privacy questions, and legal experts then produced answers for these privacy questions. I'm not going to go into too many details in the interest of time, but what we found broadly was that this allowed us to get a better understanding of the types of questions users may ask and how they would ask them. And we saw that the current state-of-the-art NLP methods like BERT were considerably behind human performance at answering these questions. And our paper describes more aspects of why this problem is so challenging. Okay, so thus far I've discussed applications, NLP applications, which aim to make privacy policy information more accessible to users. But now I want to talk about an application that's going to make this information more accessible to consumers and regulators. So we know that there are millions of apps in the Google and iOS app stores. In 2012, 6 app platforms entered into an agreement with the California Attorney General that they would encourage their developers to provide privacy policies. But these app platforms, it's kind of unknown to what extent they are actually enforcing these requirements. And moreover, many developers lack the resources and know-how to ensure that their apps are actually going to be compliant with these requirements. And this gets more and more complicated. So even if an app is compliant at some point in time, regulations change and the app may no longer be compliant. And regulators typically don't have the resources to monitor a large number of apps for compliance. So how can NLP help here? So I want to talk about this work led by Sebastian Zimick called MAPS. And the idea is basically that they used NLP classifiers to identify data practices in privacy policies. And they used static code analysis to analyze app behavior. And the results of these two analyses were combined, so they could use this to tell when a privacy policy described a practice that was discordant with what the app behavior actually was, or vice versa. So the cool thing about this is that this was actually used by a large-scale electronics manufacturer to monitor a large number of apps for compliance, and was also used by the California Attorney General at the time, Kamala Harris, to monitor apps for compliance. Okay, so far I've described some of the early success stories for NLP and privacy. But this is applying these technologies in this domain is actually challenging, and I'm going to talk about some of these aspects. So privacy policy language is complex. So we see a lot of ambiguous and vague language. For example, this policy says the entity will collect non-personally identifying information of the sort that mobile applications typically make available. So it's kind of up in the air what information types would probably be under this definition and what would not. Privacy also developing. So developing technologies for this domain also requires understanding a lot of aspects of web document structure, because a lot of information privacy policies is present in headings and or like in this example, formatted in lists, which could be complete or incomplete. So we really need new kinds of techniques that are able to more effectively leverage this context in how they understand privacy policy language. So another challenge is that privacy policy formats are also constantly evolving. So now more and more privacy policies have started presenting information in the form of tables. And there's a lot of variability in how these tables are formatted and how they present their information. So we need to start adapting uh, our previous privacy NLP technologies so that they also work with new formats. And these are some of the challenges for building effective NLP technologies. But we also see that the problem space itself is complex. So the study by Reidenberg et al. Found that even experts can disagree on the interpretation of policy language. And the fact that experts interpret policy language differently and that experts and humans interpret policy language differently means that um, uh, means that this is actually a really challenging task even for humans. And this has implications for how we would be able to construct any automated technologies in this space. Further, modern NLP relies heavily on data, but collecting annotations at scale for privacy policies for many of these tasks requires legal expertise, because a lot of the time, the output of the NLP system would have legal implications. So we really need more legal scholars to be willing to contribute their time and expertise to building more resources in this area. Finally, we really want technologies in this area to be able to help a broad range of users, including help users with a range of visual impairments navigate their privacy. So we definitely do need to conduct more user studies to see to what extent technologies are equitable and can actually help a variety of users navigate their privacy online. Okay, so far I have described successful applications of NLP and challenges, but now what I'm going to describe is future applications where NLP can help, or applications which don't exist yet, but are probably going to be exciting opportunities in the future. So one application I'm excited about is being able to detect surprising statements in privacy policies. And surprising statements often happen when a user's expectations don't align with what a service actually does. And in the long term, these kinds of mismatches can lead to a loss of user trust. But this is actually a really challenging problem because it requires understanding social norms to see what would actually be upsetting to a user, understanding sectoral norms. So for example, a financial website shouldn't be, it's surprising if a financial website collects health information, but maybe not surprising if your fitness tracker collects health information. It requires knowledge of the different privacy information types, and it requires a deep understanding of the personal, social, and cultural background of each user. For example, a user with more technical expertise might recognize that if a service is collecting IP addresses, it might also be collecting approximate location information, because this can be inferred from IP addresses. But a user with less technical expertise might find this more surprising. The second application I'm interested in is about dealing with privacy nutrition labels. So privacy nutrition labels are meant to disclose to a user at a glance the information a company and any third parties collect. And Apple actually requires developers now to provide this information. But this is extremely challenging because developers need to ensure that these nutrition labels are accurate, and platforms may need to enforce compliance too. So what I'm interested in is seeing if some of our early success in compliance analysis can be leveraged here. So can we use NLP techniques to automatically validate the content of nutrition labels based on what a privacy policy actually does, and also based on app code's behavior? And is it possible to use NLP to at least generate a first draft of these labels based on what is actually in the privacy policy, which developers can then iterate upon? Third, I'm interested in the potential of personalized privacy summarization, and there's a real need for this kind of application, because as we saw with summarization approaches, generic summaries may not be sufficiently complete and they may miss out on important information. Question answering overcomes these limitations, but it's likely to favor users who are better at managing their privacy by asking the right questions. So there's potential here for developing personalized privacy policy summaries that are tailored to the interest of each user, and then using question answering functionality to allow users to iteratively and selectively explore further. So that concludes this talk. Broadly, I've described applications of NLP in the privacy space. I've described why it's challenging to build these applications, and I've described a vision for what the future of this space would be. But at a high level, the key takeaways is that it's impossible for people now to keep up with how their data is being collected and used. And there's a real opportunity for language technologies here to make an impact in this domain, which extends to virtually every internet and mobile users. And doing so, so to do so, we will need tools that help users more effectively navigate policies. We need tools that can help and assist regulators to enforce compliance across services. And we need tools that help companies and developers put forward compliant privacy policies and nutrition labels in the first place. Thank you. So a lot of the resources that I've described in this talk are available at usableprivacy.org. And I'm happy to take any questions now or later.
Great. Thanks, Abhilasha, for the great talk. Following our standard format, now we have some discussion, some comments from Catalina from a legal perspective, and then we can have question and answers from the audience for both Abhilasha and why not for Catalina as well. Cool. Catalina, the floor is yours.
Thank you so much. And first of all, let me start, Abhilasha, by saying that it was really a pleasure reading your paper, among others, because I think that out of all of the NLLP talks that we've hosted this year, this was the paper that I personally could comprehend the best. So thank you very much for giving me the opportunity of actually reading an NLP paper from head to end and then actually understand it. So it is a pleasure to be able to comment on it. And I have even, just to fall into the cliche, I, as a legal scholar, printed it, wrote comments on the side. And I really hope that these comments can help us create a healthy interdisciplinary conversation around also, or build on your research and try to understand what exactly can be also done in the future. So in order to do that, I'm going to try to group my comments on the basis of 4 main pillars. And then I'm going to try to give maybe more specific examples with these particular notes. And if you want, I can also just scan the comments and then send you the PDF later on. The first one is the idea of, or the main question of what the value of NLP is for procedural fairness. And let me start by saying that I am not a privacy expert. I do consumer protection that also in the European Union very much deals with consumer contracts and the way in which consumers are supposed to have a role in transactions that is not so completely imbalanced in comparison to the type of companies and the kind of platforms that you were describing. Sometimes, especially when it comes to digital markets, might really overwhelm consumers with a lot of information. And just to kind of build on this idea of procedural fairness, so if you look at, you even mentioned in your own paper, you know, that privacy policies differ from several other closely related domains, such as legal texts, which are largely meant to be processed by domain experts. But for instance, if you look at just terms of service, so privacy policies you can consider to be an annex to terms of service. I'm very happy. I'm looking at the list of participants, and I see Roberta Kuster, who is also a legal expert. So Roberta, if you have comments or questions towards the end, let's go into that as well. But basically, there can be some legal discussions as to, you know, privacy policies are part of the terms of service, or they're an annex, or they are, as you also mentioned, kind of they have legal effect. But at the end of the day, they're all the same thing. They're clauses that are supposed to be communicated to the consumers with relation to the balance between the rights and obligations of the parties to a contract. And in doing so in the European Union, for instance, there's a really, really wonderful instrument, the Unfair Contract Terms Directive, that has also created certain, or has led to the outlawing of certain practices. For instance, to give you a very specific example, if you're going to have any kind of policy of a platform that will say, we need to do arbitration. So funnily enough, Niantic, the producers of Pokemon Go, used to have this, and used to have this as also as an, you could have opted out of arbitration. That in the European Union is completely unlawful. So for instance, this particular directive, the Directive on Unfair Contract Terms, also says that terms to a contract, and you could even apply that to privacy policies, they need to be in plain and intelligible language. So even general terms and principles should be made available in plain and intelligible language. The only problem then, and I think that that's first a legal question, and then secondly, that is a question that can be translated to NLP, then the question would be, you know, what is the level of specificity that of the language that would be necessary to still convey knowledge that is specific to a domain? Because in a way, I look at a lot of these consumer issues, and in my humble opinion, based on my research, you know, there are certain solutions that might solve certain problems that then create other problems. Because if you're supposed to maybe use legal terms, perhaps in some ways you're going to be more specific, so there is more clarity from a legal perspective what you mean. But then using plain terms maybe could lead to more uncertainty as to what exactly those terms could actually lead to. So this is part of the procedural fairness question. So this idea, this is an example with the unfair terms. It's part of this procedural fairness because it is an example of how you disclose information to consumers in such a way that you empower their choice architecture. So consent as a legal institution that we've had for millennia in law in various continents, then consent is still something that is protected, but it is protected in such a way that allows less of an imbalance between parties that have very, very different bargaining powers. So I think that would be one main question, this reflection of what is the value for NLP for this type of procedural fairness. And to build on this, I think for me, there's also, and also because of the contra questions that came to mind when reading your really wonderful text, the question is also, what's the role of privacy in the ecosystem of all these other policies. Because then, for instance, if you look at social media platforms, there's going to be community guidelines, there's going to be terms of service. Nowadays, because of trends like content monetization and general monetization, you're going to have commerce policies. And all of these interact in ways which, as you yourself were mentioning, not just on the basis of Joel Reinberg's work, but on the basis of the reality of legal interpretation. Basically, you apply privacy, but then you also apply contract law, you apply consumer protection. So these are, just on the top of my head, 3 legal fields that interact and create tensions between different provisions that are going to be considered under this, the umbrella of the private rulemaking by different digital platforms. And not to mention one thing which I am absolutely fascinated with, and so I saw that you mentioned you had the section 3.1 with data practice identification, and you also mentioned a very nice corpus of annotated privacy policies. And for me, that raised a question of privacy policies from where? Not necessarily which websites or which specific platforms, but gathered with what IP address. Because, and this is where I get to the point that I'm fascinated with, I think that we have inherited from earlier iterations of, especially internet law, we have inherited this concept with which some people find very old school, the concept of cyberspace. But actually, if you look at different policies, especially privacy policies of, you name it, any platform that operates, for instance, in the United States, in Canada, in Singapore, in Australia, and in the European Union, you will actually see the apparition of cyberspaces. So there's going to be one set of terms that will be applicable perhaps to North America and India and Brazil and Singapore. And then you will see this kind of island. Oh, wow. In Europe, there's the GDPR and there's European consumer protection. And that will affect the way in which these policies are going to be drafted. So I think for me, also the question is, what is the similarity between the various policies that can be recorded with different IPs? And also, can we speak about, for instance, like a very classical comparative law concept, which is called legal transplant? Can we see this legal transplant from, Californian law, then to jurisdictions completely around the globe, but then kind of walled, or with certain jurisdictions being walled, to use the metaphor in your paper, against this by having stronger regimes, for instance, in the European Union, as I was giving the example. So I think this idea is definitely something that can be worked into the future work, especially in the light of the context of privacy policies, in the light of the context of the many other forms of documentations that platforms are going to have. And here, what I can immediately think about is, and you were also, and I was very delighted to read that in section 3.3 with the compliance analysis. I thought that it was fantastic that NLP can be used for compliance purposes. Then I also asked myself, how can you triangulate NLP maybe with other approaches, for instance, like from web measurement studies? Because on the one hand, as you were mentioning also in the paper, there's looking at the policies, what the platform says it does is one thing, and what the platform actually does is a completely different thing. And we have seen this distinction, especially, again, as you frame it yourself, this distinction between what policies will say and what they will be silent on. We have seen the failure of these kind of approaches in the Cambridge Analytica incident, where if you looked at the extended permissions that Facebook was giving through its API, such as read inbox, that was nowhere in any kind of policy, whether the terms of service or the privacy policy, it was just not included that it would share such private data, such as that data that was exchanged in private messaging with third parties without necessarily specifically informing consumers about that. So this is where I think that perhaps also the the bridging of multiple fields of computer science. So NLP plus maybe, as I mentioned, elements of web measurement, or maybe methods that are more specific to privacy and security. I think that, or even human-computer interaction, then that could be perhaps something to investigate in the future as well. Which brings me to my third point. I think you mentioned at the very beginning, so I was really interested in the studies that you were citing. I would like also for your curiosity, if you are curious about this, to share some additional studies. There's actually a study in behavioral economics and also in contract law. I was very happy to see Marota Vergler mentioned in the list of citations. So this is for everyone else who might not know her, this is Marota Vergler is a professor of law at NYU, and she has been doing a lot of empirical research on contracts. And just like her is also Omri Ben-Shahar, whose work I just linked in the chat. And Omri Ben-Shahar has conducted a study in 2016. I had the pleasure of actually listening to an early version of this work together with Adam Chilton. And in 2016, they did an experiment, and they said, to, I think, 1,484 users they recruited in a very kind of misleading way, saying, hey, we're a company, we're actually trying to make a dating app. And then they were asking these participants in the experiment about really risky sexual behaviors, because they hoped that these kind of answers would elicit a reaction in terms of, oh my God, what are these people doing with my information? So let me read some privacy policies about how the results of this study will be used. And basically what they show in that paper is that with this particular sample, which they have kind of created or defended as representative, but it's, of course, it's one study, they show that users actually didn't really care about their information, even when it was just so vital. So I think that maybe another question can be asked about how the behavior of people is changing. I don't know, I don't see immediately maybe a role immediately for NLP, but maybe this can be part of the context in which the questions, the very interesting questions that you were sharing also in point 3 of your presentation. I think that this can be maybe a context in which these additional research questions can operate. So do we see a change? Are we noticing the fact that people don't care about privacy because, or didn't used to care about privacy because, as Omri Ben-Shahar was saying, like simplicity or simplifying these kind of very complicated, business practices on digital markets that are so opaque and that are so complex, it's impossible to simplify something that a consumer simply doesn't have knowledge about. So it's kind of simplifying the unknown, but how do users actually relate to this unknown? Or are we speaking about, so is that what's happening? People don't really care about privacy, or was this only the case at a specific moment in time? And now with people getting, more native digitally, with all of these kind of cliche examples with children who go to and take newspapers and they try to swipe pages on newspapers, can we say that there is something that is changing also in the way in which consumers behave towards their or apply their own expectations when it comes to the privacy that they would like to receive from different services? So I think that this question, how can you do this across time, or how can you investigate this across time? Perhaps it could be useful to do some sort of a kind of a meta study of these kind of behavioral studies, and then build with NLP research on this context. So that was the third comment. And then my fourth comment and my last comment before we can move to the questions. The comment dealt with something that I already mentioned very briefly, the idea of compliance. One of my friends, Thibaut Schrepel, who's part of the program committee of the Natural Legal Language Processing Workshop, he organized a codex event earlier this week, and he brought together 50 competition authorities around the world who all wanted one thing, and that was how to get knowledge on how compliance can be done on digital markets. And for better or worse, digital markets and interfaces have a lot of text. So then NLP is the go-to type of field of computer science that can be helpful in the development of this type of legal compliance. So I think that for that to happen, it would be interesting to see a development in the NLP field of maybe more let's say multiple, like transfer learning. How can you take the laws of a specific jurisdiction and how can you build on that and try to look at the laws of another jurisdiction, understanding similarities and differences between laws? Can we create some sort of a corpus of rules that we can extract from legal standards that are going to be maybe with some differences the same? There's going to be kind of this common core of rules in a specific field like privacy that will transcend jurisdictions. And then how do differences actually come and top that up? And so I think that this is something that moving forward and developing what is called in a lot of this literature, public interest technology, it would be very interesting to bring more specificity to, so to say, you know, this is the specific jurisdiction, these are the standards, and this is how these standards are different than in other jurisdictions. So I think that these are just some initial thoughts that I had. As you can see, perhaps kind of quite an avalanche of them, but that's also just thanks to your inspiration and thanks to the fact that you wrote a fantastic paper together with your co-authors. Thank you so very much for giving me the opportunity to mention all of this, and I look forward to your answers and or contemplations and also questions based on this in the chat or from whoever wants to take the floor. Thank you so much.
Cool. Thank you, Catalina. So people can start writing their questions on the chat. I don't know if Abhilasha, you want to have a first reply to Catalina's comments, and then I have some questions that are, I guess, more boring than Catalina ones.
Yeah, thanks, Catalina, for that incredibly in-depth analysis and so many exciting ideas. I just want to briefly mention actually that my collaborator, Tom Norton, is also here, so he will also be interested in this discussion and contributing to it, I'm sure. Yeah, so you had many fascinating points, and I agree a lot of them are going to be very interesting research directions in the future. One of the things I'm interested in and which we are actually studying right now is what you mentioned about how different jurisdictions are going to be having different kinds of privacy policies. So we are actually analyzing exactly that question, but again, through computational methods. So we are looking at the difference between US and EU privacy policies, for example. And what we are finding is that there are actually a lot of spillover effects. So protections from the GDPR. Many apps use similar privacy policies across jurisdictions. So those are extending sometimes to also the US users. So that's just like a little tidbit which we found interesting. But yeah, I'm super curious if you have like more thoughts along that area and what would be like interesting questions that we should really be thinking about in that space.
Cool. Should we take some questions, or Catalina, you want to reply straight away?
I mean, just a very quick note. So that's fantastic. I think maybe just brainstorming also on the more legal implications of, for instance, when you mentioned, you know, like US and then EU privacy policies. So that's fantastic when it comes to, for instance, the more centralized approaches that platforms have. So Facebook is going to have the same privacy policy for the entirety of the United States. Now, the main problem is you identify in the paper, and also Tom, congratulations also to you for this wonderful paper that now that we know that you're also in the room. So I think that's one viewpoint. But then, for instance, like as you identify in the paper, the Californian law that was inspired by the GDPR, that is something that applies in California. So then we have this interplay between mandatory rules that are going to exist at state level or in the European Union at country level, and then the more federal / European rules. And it is true, for instance, in the European Union, the GDPR is a regulation. So as such, it should apply directly to a lot of, or actually to all member states. But there are also some specific aspects which maybe member states are going to take on. So, and they will have to build upon. So for instance, one of them being the research exception, which I've seen the NLP community be interested in for many other purposes and on other occasions. And then you have additional national law that will complement that. So I think for the more generic parts of the GDPR, let's say the core parts, not to remove that their importance, but the core parts, they will be the same. Maybe like the grounds for processing the legal grounds for processing personal data will be the same. But then, for instance, you might have, it might be a nice opportunity to link to some case law that defines personal data and to say, okay, so this is clearly personal data. Can we do something with that information? So the problem with legal standards is that indeed a lot of the times they're going to be so generic because they need to cover a lot of situations. And then what will happen is that for more certainty, you need to see how have certain situations been tackled in the past. And then that's where you look at case law, Ilias's backyard. This is how you look at case law, but at the same time, there is also a limitation because as interesting and as exciting some issues might be, perhaps they won't lead to case law. And then even the legal community is like, well, no, we interpret it like this, no, like this. And then it's like kind of an intellectual battle and not necessarily a lot of certainty. But I see that the questions are flowing, so perhaps we can focus on that.
Cool. We have a question by Hugo. Hugo, do you want to say your question yourself instead of me reading it?
I think I can do that, Elias.
Cool.
Yeah, well, thank you very much. Hugo Lopez from Copenhagen University. Thank you very much for your presentation. We've been working in compliance and digitalization of text based on formal models and NLP. And one of the questions which I found really interesting from your presentation was the part of question answering, especially when we try to make sense of a law. One thing that happens is that when I try to make sense of an article in the law, it tends to have multiple references, not only to one section, but also to many other policies. So when I'm trying to really make a question answering, it might even, like, I might need to consider this long distance relation. So I don't know whether you have considered that, and if you do, what kind of techniques are you using in that? And then the other question is, well, so far you're talking about computational methods, but there's also a lot of questions regarding how do we interpret certain words? And I wonder whether you've been also looking at the formal, like the link between the computational methods and formal methods.
Yeah,
just
so
to decrease the ambiguity. Yeah.
Sorry? Decrease
the ambiguity of some of these words.
Yeah. So those are great questions. So what I will say is that these are challenges that we've recognized. So like a lot of the time when a user asks a question, for example, information about that question may not necessarily be present in the privacy policy like you described, but it may still be possible to describe things based on relevant regulation or relevant statistical knowledge. Like, you can say things like, oh, this particular policy is silent about whether the app collects this or not, but other similar apps typically collect this kind of information. And those kinds of answers, about things that are not in the policy are actually going to be super useful. So privacy question answering in general is at a really nascent stage right now. For example, our paper, which contributed the data set, came out 2 years ago. So this is definitely a very exciting area, and there's lots of potential. So far, most of so there are 3 privacy QA data sets so far, and most of them have stayed away from interpreting the content of privacy policy. So usually they identify sections in the privacy policy and present them back as answers instead of trying to tell the user or make any kind of judgments about what the policy is actually describing. So I agree, like interpreting particular terms in the privacy policy is going to be very useful, and interpreting them in the context of specific regulation will also be useful. But yeah, we haven't had work in that space yet because this field is still just very new. It's a great question.
Nice, thank you both. Pooja, you have a question? Do you want to describe it better than
Just
me?
say it because I first raised hand and I thought we are doing some kind of round table, but then I just posted my question to make sure that people don't forget. So I see that the question, the talk is quite much intended for legal laws or law system basically, and I'm here from software engineering field. So my question is more for developers who develop different apps. And generally, when we develop apps, to be honest, we don't understand any of them, any of the policies. And there are so many different kinds of policy. If I'm making an application, let's say a camera application or a health application, I don't know, first of all, which all policies would be applicable in my case. Even though somehow I gather this information, I don't know how to embed it in a nice way. I would just put a text document and let the user read. But then, to be honest, it should also be a bit of my responsibility to see that what my app is doing to their data. Like somehow I should be also responsible for my part. But the problem is how to make this process easier for developers, how to make them understand what policies are applicable for their app. Sometimes they embed policy because somebody did and it's not necessary. So the information should be targeted at that level also, that we scrape it there only and it doesn't reach user because user doesn't need it.
Sorry, could you repeat the last part again? I didn't quite get that.
So I feel that the target here, it's not should be user, that we give less information to user. It should also be to developer, that they understand that their application is not related to this data, that they shouldn't embed that privacy policy in their application. And how do you think we can go in this direction? First of all, how can we make sure that developers understand the policy system? The second is how they present and include, how we influence that part.
Yeah, that's a great question. And it's really challenging because a lot of developers don't really have the know-how to know yeah, whether their privacy policy is accurate or not. And what we found is also that a lot of people use, a lot of developers use privacy policy generators. So they'll automatically include a privacy policy which may or may not be accurate. So I think there's a lot of potential here to build technologies that are extensively meant to support developers. So like the compliance analysis kind of technologies I was discussing, they may at least be able to identify if there's anything in the privacy policy that that is discordant with the app's practices, or that is missed out on, which the developer really should have something about. So that's one application. So again, with the nutrition labels now, I think that's NLP techniques are pretty good at like when information is presented in a fairly consistent way, they're pretty, you can pretty effectively build NLP technologies like we saw with the choice extraction technologies. So I think it might be possible because nutrition labels have these predefined fields and we know how to identify data practices. It should be possible to kind of build technologies that can at least provide like some starting set of nutrition labels for developers. So I think to get the perfect privacy policy, you will have to consult with people with legal expertise. But
do you have any data set in this direction, like in nutrition label, any data set like which we can start, or any paper that is already trying to work from developers perspective, or for for their needs, or some work where they identify developers need regarding privacy policy?
It's one of our focuses for next year. So
Ah,
hopefully by
okay.
the end of next
So I
year,
have to wait for a whole
this
year, or maybe I can be a collaborator.
Oh yeah, our group is really collaborative. So if anyone has any interest, yeah, they should reach out.
I found it very interesting, this area. Although I don't have much expertise, but this sounds very cool, and also like it, I feel like there is a huge need.
That's great to hear. Yeah, I agree.
Yeah. Thank you very much for answering the question.
Thank you.
Great. Thank you both. Any other question from the audience? Otherwise, I'll just do my own question. Okay, I'll go forward. So my question is for both of you, both Abhilasha and Catalina. So you both discussed a bit about personalization. So privacy, of course, is a thing that, as Catalina said, sadly, many people don't really care about it. And some other people may care a lot about it. So my question is, in terms of technology, what can we do from an NLP perspective to adjust, our models or final products to adjust to the personal needs of a user? And Catalina, would like your opinion of how legal is this? How lawful would be for an application to do this automatically on the fly, or how would they have to frame this in the term of service agreement to be able to do that? I don't know who wants to start. Abhilasha, maybe you want to start.
Yeah, I can start. Yeah, so I really like this direction of developing more usable NLP technologies and models that can adapt to individual users and their requirements. I'm excited to hear Catalina's viewpoint from the legal perspective, but from an NLP perspective, um, I think this will be really interesting and useful because different people do have different interests, like you mentioned. They also have different expertise and levels of background knowledge. So if you can have systems that can simplify the text at the cost of deleting some nuance to present it for users with less technical expertise, but that can have all the information that is required to present a answer or a summary for users with more technical expertise. I think this is really valuable to have these kinds of adaptable systems. But I'm really curious about what Catalina will say about this.
This links very much. I think this question is really fascinating, and I was actually making notes about this because when you mentioned the entire idea of question answer, this question and answer approach that can really be used to really kind of tailor a specific type of knowledge level to a specific user. This is very much in line with what I was asking earlier about the trends, so why do people not care about their privacy? Because for instance, we have colleagues also at Maastricht University who have been working very hard on the development of these kind of like nutrition labels, or you can call them maybe like icons, like privacy icons. For instance, the Italian data protection authority held even a competition with, kind of a call to arms to develop these icons and let's start using them. So I think that perhaps for Pooja, this could be, I'm going to try to search for that and put it in the chat. This kind of, public event could be interesting because it also very much was supposed to include stakeholders like developers. But the thing is that, so that's something that is currently being looked into with the hope that perhaps with some degree of personalization of the disclosures, then maybe disclosures are going to be more effective. And the reason why I keep on sharing scholarship from Omri Ben Shahar from the University of Chicago is because he has been working very much on behavioral studies and behavioral consumer studies. And so he is one of the leading authors who has been claiming that disclosures don't really work because people don't care about them, because they are not really rational, and they're not going to weigh their information in such a way to make very clear and rational decisions, or their rationality is bound, as it is called in this scholarship. But I think so. He also built on this particular scholarship that he authored in the past, and now he has a book on what is called the personalized law. So this idea that, okay, if we are living in a data-driven society, can we not do more than just put people into boxes that are kind of like 3 boxes, you know? So to give you the example of consumer protection in Europe, we have a box for the average consumer, a box for the vulnerable consumer, so on and so forth. So then if you don't fit in these boxes, then that's a problem. So when a judge is going to try to make you fit, okay, we put you here, we put another user here, but is this type of profiling sufficient for the amount of detail that we have in dealing with users? The lawfulness of such models, I think that's a different story, because I think then the question would be indeed to what extent these models relate to existing law. So that would also be a matter of checking or cross-checking that consistency. But I think it is for sure something that is very much worth investigating in the future. So I'm very happy to also, hopefully we can have Omri Ben Shahar with his idea of personalization, as he calls like different, so far we have had kind of the same law for different people, and now we can have different rules for different people or different disclosures for different people. So I think that that's really a fascinating line of research indeed.
Thank you both. I'm super interested in this part in general because, you know, I think this applies if we go outside law, even if you think about, you know, toxicity classifiers that we built in NLP, and then we have, you know, we have to define what toxicity is and how the system have to behave, and then you have so many people with so many different standards, and of course you have a bottom line, which is, you know, this is hate speech, this is under law something that is not okay, but then there is a very gray zone where people have completely different ideas of what is toxic or not, and then the system ideally would probably adjust to their kind of standards unless of being completely doing censorship of whatever. Anyway, do you have any other question?
I have just a follow-up question for you. As you mentioned toxicity, so you meant toxicity which is written in this law document?
No. I mean, in general, you know, in forums we have people discussing,
or in
Facebook
forums
we have people discussing, and you know, there have to be technologies that, you know, try to somehow regulate the situation there and flag posts or not. And most of this right now happens automatically for many cases, and I guess they have pretty low standards or high standards compared to what personal beliefs are of any of us here. And ideally, this could be adjustable to our personal views and not be, you know, super sensitive or not sensitive at all. It would be nice to have something that it's more dynamic.
Right, and if I understand you correctly, then right now what you have is like Twitter. It's like you have porn or you don't have porn. So it's like
true.
Very binary in a way. And then those are these kind of, you know, labels. It's like lawful, unlawful, right? So maybe you can have you can have kind of a scale of lawfulness, and then perhaps I don't know if that makes sense. So I have to think about that myself as well. But I think that you can maybe have a scale of profiles, and then on the basis of the profiles, then you can adapt legal rules, because then you consider vulnerability in a greater or a less great weight, let's say, to what you're supposed to display, right? So. Yeah, but I think so your example, Ilyas, if I may reflect on that, I think it's also quite specific because there's it's a very specific problem, because it's an area that has a very high level of legal uncertainty, whereas I think privacy and what Abhilasha and Tom have been working on, I'm very curious if Tom has any remarks or any kind of considerations from a legal perspective, especially from across the ocean. But I think that at least with privacy, there are certain things that can be standardized, and maybe this can also lead what Pooja was asking earlier, actually, it could lead to more focus on small and medium enterprises, because one of the main criticisms of very high standards like the GDPR is that they actually include or imply transaction costs that are very, very, very high for low, let's say, small companies. Whereas then Facebook is not going to feel that burden of compliance in the same way, as Hugo was mentioning, that Hugo, you were focusing on legal compliance, but legal compliance is also something that comes with certain costs. And yeah, the higher the uncertainty or the more complex the law, the higher the burden of the law, then the more of a problem that's going to be for the small players in a market.
True. That's another interesting dimension.
But currently, big companies, let's say, get questioned, but generally small companies, at least in software engineering, when they develop applications, first of all, they are not aware of many laws, and then they also know that they will not be held accountable. So isn't it also
Well, I think you're putting a very good question there, because that is, when do we start involving the law in software development? And like traditionally, it has been after we're doing our software development, like especially when everything became agile, then a user story regarding compliance become very, very late in the development and testing. However, that depends on that does depend on which field of software development or to what kind of application you're developing software to. We work with the medical domain, and we work with finance, and their financial compliance, it's you cannot release without having properly tested. Same thing if you're building something software for a pacemaker. For those cases you have, but for other types,
general applications, there is nothing.
Yeah, exactly. I mean, but one thing which is interesting in this is how do NLP help us to generate template like guidelines on what do you need to check, and it's something that we've been looking at, reference models of law, especially when it comes to compliance. And if you're talking about GDPR, well, if you need to implement some procedure for deleting personal information, where would that be, and what kind of sort of code are you going to align that to?
Yeah, I think Pooja brings up such a great point. Part of the issue is also that regulators don't really have the resources to check everyone, right? So it's to some extent a matter of priorities, and that
and the development is quite fast due to, because there is no restriction, there is nothing, people can just develop and dump and host stuff, while it's generally not it's not possible. Like, let's say in big teams, in big companies, financial domains, yes, there are compliance, but if there are small companies, they know that they can just develop, temp, host, and publish. The process is, it's not in the process that they have to look for compliance. What's this word? Nobody gonna ask us, nobody gonna question us.
Yeah, I think part of the puzzle will be to see if there are ways to help regulators at least decide what to prioritize and to be able to expand their reach with like the resources they have. Right now, yeah, it's just not feasible to check. So I can see what you're saying, that a lot of developers will just go ahead and Catalina had a comment.
And now I have to jump to the next call. I'm really sorry, but it was really great, and I'm very happy I attended it. It's a very new world, but very interesting world. And thank you very much for great questions.
Thanks,
Thank you too. And I guess we don't have any other question. We can pretty much close. I have a final announcement. The final announcement is that me and Catalina discussed and think that we are going to have kind of a seminar or a book club for introduction to law for NLPers, which I guess it's super interesting because, you know, I actually asked her, you know, what I have to read to understand law, whatever video I have to see. And she told me that she's willing to kind of lead this thing. And I guess it's great to have this meeting where we can study and then have some interesting discussion like this one on very general topic, abstract topics, or maybe later we get into super detailed conversations like we had today about privacy and what aspects of that. So we'll possibly discuss a bit more and we'll make some announcements early next year, I guess, and ask you when are you available for this kind of meetings and what you expect us to have there as material and discussions. Cool. So if we don't have any other comments, I guess I have to say good night to all of you, at least from here in Greece. And good morning or good afternoon for Abhilasha, I guess.
Morning.
Morning. Cool. Anyway, thank you all.
Thanks, everyone. Thanks for having me.
Have a
Thank you,
great weekend.
Thank you for
Bye.
everything. Thank you for your presentation and have a lovely weekend.